Hello, welcome back to another lecture video for Law 2023, Business Laws and Regulations. So we are still on the law on partnerships, particularly dissolution and winding up. This is the third video for this topic. So hopefully on this lecture video, you'll be able to finish dissolution and winding up of partnerships, so we can already proceed with limited partnerships and credit transactions. So we will continue with Article 1837, which is a very long article, actually. Ang haba niya. So we will tackle this article per slide na lang, per slide. So for the first portion of Article 1837, sabi ng batas natin, when dissolution is caused in any way, except in contravention of the partnership agreement, each partner, as against his co-partners and all persons claiming through them, in respect of their interest in the partnership, unless otherwise agreed, may have the partnership property applied to discharge its liabilities, and the surplus applied to pay in cash the net amount owing to the respective partners. So for the first portion, una natin titignan yung um, situation kung kailan mag-a-apply itong first portion na ito. Ang sabi niya, una, may dissolution. And that dissolution is caused by in any way. So kahit ano yung mga dahilan, we have discussed this before, yung mga grounds for the dissolution of a partnership, except that this portion of Article 1837 will not apply if the cause of the dissolution is in contravention of the partnership agreement. So, just to quickly refresh our memories, di ba? Ang pag-dissolve ng partnership may or may not contravene the partnership agreement. May mga sitwasyon kung saan wala namang violation ng partnership agreement since they already agreed upon it beforehand. But for example, they agreed for a partnership with a fixed term. Ibig sabihin, beforehand, alam nila kung kailan ma-dissolve yung partnership. Since sa inception pa lang, actually prior to the inception of the contract of partnership, the partners already agreed kung hanggang kailan or hanggang saan ba aabutin yung partnership nila. At kapag dumating yung panahon na yun, like for example, 20-25 years, the partnership will be dissolved. And that dissolution, the cause of the dissolution, is not in contravention of the partnership agreement. Since it is not in contravention of the partnership agreement, this portion of the provision, this portion of Article 1837 will apply. So, on the other hand, for example, they agreed on a partnership which will run for 50 years. That's the agreement. And then there's this one partner na ayaw niyang hintayin yung 50 years. Sabi niya, dissolve ko na to ngayon. Again, we have learned before that actually can be done. We cannot prevent a partner from disassociating him or herself from the partnership. In fact, we have repeatedly mentioned that um, you cannot compel, you cannot compel a partner to continue with the partnership, and that the partnership is the relationship among the partners is fiduciary in nature. Once a partner loses that trust and confidence, then not even the courts can compel him to continue with the partnership. Even if the partnership is for a fixed period or fixed term, if at any time a partner feels na ayaw niya na doon sa partnership, then he can always withdraw from the partnership. However, that withdrawal is in contravention of the partnership agreement. It will cause a dissolution. No? That will not prevent the dissolution, even if it was made in contravention of the partnership agreement. The dissolution will proceed, no? Kapag nag-withdraw na yung isang partner. even if na-violate yung agreement. Kaya ko binanggit yun, this portion of Article 1837 will not apply because sabi niya dito, except if the cause of the partnership dissolution is in contravention of the partnership agreement. Kapag ganun yung situation, wala. This portion rather of 1837 will not apply. Okay, so on those situations kung saan yung dissolution ng partnership is not in contravention of the partnership agreement, what will happen or what does this provision mandate? Sabi niya, each partner, so lahat sila. Bakit? Kasi wala namang guilty partner dito eh. Diba? Because the dissolution is not in contravention of the partnership agreement. So each partner, lahat sila may karapatan. Each partner, as against his co-partners, ibig sabihin, yung karapatan niya na ini-invoke dito ay against sa mga kapwa niya partner. And all persons claiming through them in respect of their interest. Ano ibig sabihin ng interest nito? Interest in the profits and interest in the surplus. But when we see interest in the partnership, yun yung pinag-uusapan natin. At ibang profits and surplus pwedeng i-assign sa ibang tao, third persons, pwede. Diba? Ito yung right number 2. No? To recall, meron tayong tatlong rights, property rights of a partner. Yung una ay right number 1 ay rights in specific partnership property. Number 2 ay interest in the partnership which pertains to rights to share in the profits and in the surplus. And right number 3, yung grupo na yan ay right to participate in the management affairs, in managing the partnership affairs. Sabi natin, unique yung right number 2 kasi yung right number 2 pwede mong i-assign sa third person. Yung 1, hindi pwede. Yung 3, hindi pwede. Hindi pwedeng hindi partner tapos meron siyang interest in specific partnership property or hindi siya partner pero nag-manage siya ng affairs ng partnership. Walang ganon. But with respect to right number 2, third persons can avail or can enjoy this right. Kung inassign ng partner, then okay. So dito yung Article 1837, ang tinutukoy niya ay yung karapatan ng partner doon sa mga kapwa niya partner at doon sa mga third persons na nag-claim ng right of their interest. Ito yung tinutukoy niya. Yung mga na-assignan ng isang partner ng kanyang interest on the profits and the surplus. Taktawan muna natin to. May have the partnership property applied to discharge its liability. So yun yung una niya karapatan. In case may dissolution, itong partner na ito against his co-partners and those third persons may ask that the partnership property, ibig sabihin yung property mismo ng partnership ito, hindi specific property or separate property of the partners. Pero niyang i-invoke na yung property ng partnership ay ibayad ng liabilities ng partnership. Siyempre, as a partner, you are interested in doing that. Diba? Especially kung mag-dissolve na yung partnership. Pag mag-dissolve na yung partnership, all of the partners are interested in the discharge of the liabilities. And we have learned before, I think, nadaanan na natin yun, na meron yung order of preference. Diba? Merong order of preference pagdating sa partnership, assets and liabilities, tsaka personal assets and liabilities. Madali lang naman tandaan to. Kung ang pinag-uusapan ay personal liabilities, then sila yung merong priority over personal assets. In the same way, if you have partnership liabilities, yung mga partnership liabilities will have, or those creditors will have preference over the partnership asset. So hindi siya magko-cross. Ibig sabihin, wag mong sasabihin, wag mong iisipin na tama na yung mga creditors ng partnership ang merong priority doon sa personal assets ng isang partner, especially kung meron siyang sarili niyang liabilities. Diba? Hindi pwedeng ganun. Ano yan? 1:1. Although we have to point out that nananagot talaga, no? Nananagot or liable talaga. Pananagutan talaga ng personal assets ng isang partner yung obligations ng partnership, di ba? Pero bago mangyari 'yon, kailangan i-exhaust muna yung partnership assets. Bago ka pumunta sa akin at habulin yung personal assets ko, doon ka muna sa partnership maghabol kasi yung obligation na yan was incurred naman by the partnership, hindi ako. In any case, tuloy natin to, pwede nang i-invoke yun. Siyempre, totoo naman, pwede nang i-invoke yun. At kung may sobra, ito sobra, so medyo on the positive side yung proportion na ito ng Article 1837. Kung merong sobra, after mo mabayaran, di ba, may mga partnership assets ka, may mga partnership liabilities. So using the partnership assets, i-settle mo o i-discharge mo yung mga partnership liabilities. Kung meron daw may iiwan, surplus ang tawag natin doon, that surplus will be applied to pay in cash. So you have to convert it into cash and then ibayad mo sa mga partners. Ibayad mo sa mga partners. Sa ating advanced accounting, I think meron tong discussion on how to distribute yung assets, remaining assets ng isang partnership if they have undergone the process of dissolution. Okay, let's go to the next. But if the dissolution is caused by expulsion of a partner, bona fide under the partnership agreement, and if the expelled partner is discharged from all partnership liabilities, either by payment or agreement under the second paragraph of Article 1835, he shall receive in cash only the net amount due him from the partnership. So dito Article 1837, itong portion rather ng Article 1837, provides for another situation. Ito yung situation kung saan walang violation ng partnership agreement, yun yung naunang discuss natin. Itong portion na to ng Article 1837, ang ground for the dissolution ay expulsion of a partner. In-expel siya, tinanggal siya, which is bona fide under the partnership agreement. We have discussed this before. Ang example pa nga natin, failure to attend, and I think 10, yun yung example natin. 10 partnership meetings is a ground for your expulsion. So itong si X, 10 sunod-sunod na partnership meeting ang hindi niya pinuntahan, then the other partners may move for the expulsion of that partner because that is made under the partnership agreement. Okay? So sana naaalala natin yan. Kung yun daw yung ground, kung yun daw yung reason kung bakit ma-dissolve yung partnership, ano ang mangyayari? Again, unang tanong mo, will that dissolve the partnership? Yes. Because every change in the relations among the partners will lead to the dissolution of the partnership. Otherwise stated, if there is additional partner, or if there is a reduction in the partner, number of the partners, it will lead to the dissolution of the partnership. Every time may madagdag or may bumabawas o natatanggal doon sa partnership natin, it will always result into the dissolution of that partnership. Okay? So dito, expulsion of a partner pursuant to their agreement. Meron siyang violation ng agreement, ground yun for the expulsion na expel siya from the partnership. And that will cause the dissolution of the partnership. Ano daw mangyayari kapag ganyan? If at the time of the dissolution, the expelled partner is discharged from all partnership liabilities, ibig sabihin wala na siyang partnership liabilities, ba't siya nawalan? Either by payment or agreement under the second paragraph of Article 1835. Ay, nawala. He shall receive in cash only the net amount due him from the partnership. Okay, let us recall kung ano ba yung Article 1835. Okay. 1835, second paragraph daw. Nasaan siya? Wait lang. Okay, yung tinutukoy na second paragraph ng Article 1835 dito ay yung discuss natin before about the discharge of a partner with respect to partnership liability. Ang general rule natin is that the dissolution of the partnership will not discharge a partner with respect to his obligation to pay partnership liabilities. Diba? Kasi nga, ang sabi natin, nag-extend sa personal assets ng isang partner yung payment or yung obligation to pay partnership liabilities kapag na-exhaust na yung partnership asset. So dito sa Article 1835 second paragraph, maaari ng isang partner ay ma-discharge from partnership liabilities kapag nagkaroon ng agreement. No? Nagkaroon na ng agreement between the creditor, between that partner na discharge, and uh, the continuing partners, no, in case meron pang continuing partners. Yan. So going back, sabi niya, expelled partner is discharged from partnership liabilities. Dalawa paraan para siya ay ma-discharge. Una, kung magbabayad siya, or pangalawa, kung nangyari yung binanggit natin about second paragraph of Article 1835 kung saan nagkaroon ng trilateral agreement, nagkaroon ng tripartite agreement kung saan nag-agree sila na sige, discharge ka na. That the discharge the expelled partner, the creditor, and the continuing partners, if any. He shall receive in cash only the net amount due him from the partnership. So yun yung mangyayari. Kung ano man yung may iwan na net amount sa kanya, yun yung ibabayad sa kanya, and it will be paid in cash. Okay? 1837 pa rin, when the dissolution is caused in contravention of the partnership agreement, yung mga grounds na yan, we have discussed those before, the rights of the partners shall be as follows. Okay. Each partner who has not caused the dissolution wrongfully shall have, so ito yung mga karapatan ng mga innocent partner. Tandaan, every time that a partnership agreement, if a partnership is dissolved because of a partnership violation, a violation of the partnership agreement, igugrupo mo ngayon yung mga partners. You have innocent partners and guilty partners. Yung mga guilty partners, sila yung may ginawa na nag-contravene doon sa partnership agreement. Itong mga innocent partners, ito yung mga walang kinalaman doon sa violation na yan. Sa item number 1, ito yung mga karapatan ng mga innocent partners. Una, all the rights specified in the first paragraph of this article. Article 1837, first paragraph, karapatan nila yan na kapag na-exhaust na yung partnership assets, actually kapag nabayaran na rather, yung mga partnership liabilities using partnership assets at may sobra pa rin, may surplus pa rin, then the innocent partners, according to this enumeration, will receive their share in the surplus. Okay? Pangalawa, so pag innocent partner ka, meron ka daw share in the surplus. Pangalawa, the right as against each partner who has caused the dissolution wrongfully to damages breach of the agreement. So they are also entitled to damages which they may collect doon sa mga guilty partners. Again, we are grouping the partners into two, innocent partners and guilty partners. The innocent partners are entitled to share in the surplus, meaning after paying all the partnership liabilities using partnership assets, kapag may sumobra, those will be shared among the innocent partners. And the innocent partners are also given the right to recover damages from the guilty partners. Tandaan, since there is a contravention of the partnership agreement, there is in essence a breach of contract. And breach of contract is an actionable wrong, and the innocent partners, no, since they did not they did not take part in the violation of the contract, they may recover damages from the guilty partners. The partners who have not caused the dissolution wrongfully, so innocent partners pa rin ito, if they all desire to continue the business in the same name, either by themselves or jointly with others, may do so. So dahil innocent partners sila, pwede doon lang ituloy yung buhay ng partnership. During the agreed term for the partnership, and for that purpose may possess the partnership property, provided they secure the payment by bond approved by the court. So ibig sabihin dito, they will not, the dissolution will not lead to the liquidation. Diba? Meron tong detailed discussion sa previous lecture videos natin. Dissolution is not always leading to liquidation. They may still continue with the business. So Article 1837, this portion of Article 1837 confirms that. But that can only be done by the innocent partners. No? The partners who have not caused the dissolution wrongfully. So kung gusto daw nila, pwede nilang ituloy by themselves, yung mga naiwan ng mga innocent partners, or jointly with others, yung mga ibang tao, they can ask them to join yung naiwan na partnership. They may do so during the agreed term of the partnership. O kung meron pang maiiwan doon sa term ng partnership, then ituloy nila yung partnership for that for that remaining term. And for the purpose of continuing the partnership, they may possess the partnership property. So kung baga, i-carry over nila yung partnership assets from the dissolved partnership to the new partnership or the continuing partnership, kung baga. But they have to pay the bond. They have to pay the bond which will be approved by the court. Pag sinabing bond, ito ay form of insurance. No? Form of insurance kung saan you have to apply it with the court. Yung bond na yan will be liable for any damage that may be suffered. Yan. Diyan nila kukolektahin sa or mara-recover sa bond na yan. Okay, let's continue. Or pay any partner who has caused the dissolution wrongfully the value of his interest in the partnership at the dissolution, less any damages recoverable under second paragraph number 1B of this article, and in like manner, indemnify him against all present or future partnership liabilities. So dito, sabi niya, yung karapatan daw ng mga innocent partners is to continue the business. Okay, that's one option. Or, pay any partner who has caused the dissolution wrongfully. Pay any partner who has caused the dissolution wrongfully the value of his interest in the partnership at the dissolution. Hindi dahil siya ay nag-cause ng wrongful dissolution, hindi niya na ma-recover yung kanyang contribution. Ma-recover pa rin niya yan. Ibig sabihin, babayaran mo na lang sa kanya. Since you wrongfully dissolved the partnership, ito na yung interest mo. Since ayaw mo naman, babayaran na namin yan sa'yo. Pero, dahil na wrongful yung dissolution, magkakaroon ng damages to be suffered by the partnership or by the remaining partners. In that case, inaalaw ng batas na ibawas mo daw yung mga damages na yan from the amount that you intended to originally pay that guilty partner. Hindi dahil guilty partner siya, hindi niya na ma-recover yung kanyang contribution or yung kung ano man yung owing sa kanya, remaining capital account niya. Babayaran mo pa rin yan sa kanya, pero yun nga, since he caused the wrongful dissolution of the partnership, the other partners may have suffered damages on account of that wrongful dissolution, and the law allows that they offset, kumbaga, ibawas natin yung mga danyos na yan na dinulot mo, bawas natin yan. And in like manner, indemnify him against all present or future partnership liability. Pag sinabing indemnify, damages ulit ito, you can recover damages from that partner who wrongfully dissolved the partnership for present and future. So hindi lang yung present liabilities, even future liabilities which may arise because of the wrongful dissolution of the partnership. Yan yung tinutukoy ng Article 1837, portion na ito. We're not yet done. No? A partner who has caused the dissolution wrongfully. So now we are talking about the guilty partners. No, the guilty partners. If the business is not continued under the provisions of the second paragraph, number 2, all the rights of a partner under the first paragraph subject to liability for damages in the second paragraph of number 1B of this article. Ito na nga binabanggit ko kanina. Hindi dahil ikaw ay guilty partner, hindi mo na ma-recover ang iyong share. Ma-recover mo pa rin yan. Well, yun nga, because you are the person who caused the wrongful dissolution of the partnership, kung ano man yung share na makukuha mo. Supposedly, no, your interest in the partnership, ma-recover mo yan. Pero, yan ay babawasan natin for any damages suffered by the remaining partners which was caused by your wrongful dissolution. What will happen if the business will be continued? Yan. If the business is continued, the right as against his co-partners and all claiming through them in respect of their interest in the partnership to have the value of his interest in the partnership less any damage caused to his co-partners with the dissolution ascertained and paid to him in cash, or the payment secured by a bond approved by the court and to be released from all existing liabilities of the partnership. But in ascertaining the value of the partner's interest, the value of the goodwill of the business shall not be considered. So dito, essentially parehas lang siya. Kapag ako yung guilty partner, ganun uli. Katulad dun sa right ng mga nabanggit nating unang rights kanina, pwede mong kunin yung interest mo. Kung meron mang may iwan and repeatedly, paulit-ulitan yung binabanggit, kung ano man yung share mo na yan, ay babawasan natin ng damage caused to your co-partners. And kung ano man yung ano na yan, difference na yan, it should be ascertained and paid to you in cash. Yan. Or yung bond na binanggit dito. Yan, di ba may bond na binanggit dito? You can collect on the bond. Yan. Pwedeng inaalaw yan ng provision na to ng Article 1837. You will also be released from all existing liabilities. Siyempre, kung ikaw ay na-discharge na or na-expel na from the partnership, you will be released from all existing liabilities. But in determining the value of your interest, yung goodwill daw ng business ay hindi kasama. So siguro yun na lang yung negative aspect ng pagiging guilty partner dito. No? Kung meron mang goodwill yung business in ascertaining the value of your interest na ibabayad sa'yo, less the damages, we have to exclude the monetary equivalent or monetary value of the goodwill of the partnership. Okay? Now we go to another long paragraph or another long article. Article 1838, when a partnership contract is rescinded, cancelled siya. Cancelled on the ground of the fraud or misrepresentation of one of the parties thereto, the partners entitled to rescind is without prejudice to any other right entitled to the foregoing right. So dito, sa 1838, may nanloko at may niloko. Yan. May nanloko at may mga biktima ng panloloko. So ganun ulit, you have the guilty partner and the innocent partner. But in this case, Article 1838, the guilty partner employed fraud or misrepresentation. Sa mga nauna, sa 1837, there is no mention about fraud or misrepresentation. Meron lang silang violation ng kontrata. Yan. Nag-withdraw sila, hindi pa naman time para mag-withdraw. Mahaba pa yung buhay ng partnership, pinuputol na nila. There is no fraud or misrepresentation on those cases. Absent ka for 10 consecutive meetings, walang fraud and misrepresentation doon. Talagang absent ka lang, hindi ka nakapasok for, hindi ka nagpakita or nagparamdam man lang during those scheduled partnership meeting. Although, it still amount, yung mga mga bagay na yan, nag-a-amount pa rin sila sa violation ng partnership agreement. Ito, hindi lang siya simpleng violation. Merong employment ng fraud and misrepresentation. At yung fraud and misrepresentation na yan ay nag-cause ng rescission or cancellation of the partnership agreement. So dito, sa Article 1838, ganun uli, we have to distinguish between the innocent partners and the guilty partners. So ang una nating padadaanan ay yung mga, sabi, the party entitled to rescind. Pag sinabing party entitled to rescind, sila yung mga innocent partners. So ito daw yung mga karapatan ng innocent partners to a lien or right of retention of the surplus of the partnership property after satisfying the partnership liabilities to third persons for any sum of money paid by him for the purchase of an interest in the partnership and for any capital or advance contributed by him. Pag sinabing lien, ano siya, preferential right. No? Ano, I will be preferred. Pag lien, merong property, kung sakaling mga may babayaran using that property, mauuna ako. Mauuna ako dyan. That's a lien. So kung merong kailangang ibenta na partnership assets, yung proceeds niyan, paano i-distribute tong proceeds na ito? Mauuna ako kasi may lien ako. Yan. Yung ibig sabihin ng lien. Preferential credit, kumbaga. Right of retention, pag sinabing right of retention, as the term would imply, i-withhold mo muna siya. Right of retention. You retain. Ang alin, yung surplus of the partnership property after satisfying the partnership liabilities. Ganun naman palagi. Kapag may dissolution, all partnership liabilities will have to be satisfied first using partnership property. Okay. So after daw niyan, binabanggit lang ng Article 1838 kung yung portion na ito, kung saan mag-a-arise yung lien or yung right of retention ng mga innocent partners. So kung yung mga innocent partners, magkakaroon lang ng lien or right of retention of the surplus if itong innocent partner na ito ay merong binayaran na third person and it was paid by him. Sino tinutukoy na paid by him? The innocent partner. So merong third person, ako yung innocent partner, merong fraud na nangyari, binayaran ko siya. Binayaran ko siya. Or purchase of interest in the partnership. Anong interest na to? Yung interest over profits and surplus. Or for any capital or advances contributed by him. Kung ako yung innocent partner, itong mga bagay na ito, makokolekta ko at ako ay ensured na mauuna ako makakolekta over the guilty partner. Siyempre naman, that's reasonable. Tama lang naman. That between the innocent partner and the guilty partner, dapat mauna or may lien yung innocent partner with respect to the surplus of the partnership property after satisfying the partnership liabilities kapag meron siyang binayaran na sum of money, yan, for interest in the partnership, for capital or advances contributed by him, dapat mauna palagi si innocent partner. Siyempre naman. To stand, karapatan daw niyan tumayo. To stand after all liabilities third persons have been satisfied in the place of creditors of the partnership for any payments made by him in respect to partnership liability. So, pag ikaw ay innocent partner at ikaw ay nagbayad ng partnership liabilities, technically magkakaroon lang ng novation. Nung magkakaroon ng novation, at kapag nagkaroon ng novation, ikaw na ngayon yung magiging creditor. So may utang yung partnership, ikaw na innocent partner, nag-settle ng partnership liability na yan, then parang sinabi niya to, you will take the place. You will replace that person. Hindi na ngayon yung partnership ang may utang doon sa third person kasi binayaran ko na nga eh. Na-puwersa akong bayaran siya or na-constrain ako na bayaran siya. At dahil binayaran ko siya using my own money, then yung partnership ngayon ang magkakaroon ng utang sa akin. So karapatan niya ng innocent partner. To be indemnified by the person guilty of the fraud for damages. So ito indemnity na to for damages. So dahil sa kagagawan mo because of the fraud or the misrepresentation which you employed, ang dami nangyari. Yan. Pinagbabayaran ko to lahat sa number 1. Pinagbabayaran ko to lahat sa number 2. At dahil hindi ko naman dapat binayaran yon, pero dahil nasa kagagawan mo, napilitan akong bayaran sila, kailangan mo ngayon akong bayaran ng danyos. Danyos perwisyo. So, syempre, every guilty partner, no, especially if they employed fraud or they made misrepresentation, they should be held liable for damages in favor of the innocent partners. Now we have here Article 1839. In settling the accounts between the partners after dissolution, the following rule shall be observed, no, subject to any agreement to the contrary. Paano daw ba i-asikasuhin yung mga accounts? Yan. Una, i-identify mo yung partnership assets. Identify mo daw muna sila. Una, alin-alin ang mag-form part ng partnership assets? Partnership property. Siyempre, ito yung mga kinontribute ng mga partners either at the start of the partnership or in the middle of the partnership. And then, bukod dyan sa original capital and subsequent contribution, the contributions of the partners necessary for the payment of all the liabilities specified in number 2. Number 2. Ibig sabihin, sinasabi niya dito na kulang yung partnership property. Dahil kulang yung partnership property to settle yung mga liabilities na to, we have to make additional contributions. Yung additional contributions na yan will still form part of the partnership assets. Now, you identify all the liabilities and you have to pay your liabilities in this order. Sabi time order of payment. So, una, creditors other than partners. So, in effect, third persons. Third persons rather. Siyempre, kung sino laging mauuna pagdating sa bayaran ay mga third persons kasi nga ang purpose natin dito is to protect the interests of the third persons. And then, those owing to the partners other than capital and profit. So dito, yung partner ay nagpautang sa partnership. So nagpautang siya sa partnership ng pera, pero yung pinautang niya na yon ay hindi, o yung ibinigay niya na pera ay hindi part ng kanyang capital. Ano yun? Utang yun ng partnership sa kanya. So dito, maaari na maging creditor ng partnership yung partner din mismo. At uunahin mo daw isettle yung liability ng partnership doon sa partner, but not as a partner, but as a creditor. Yung status na bilang creditor ng partnership. So the second in priority. Third in priority sa partners na with respect to capital, bayaran mo yung capital nila, and then profits. So in that order, di ba may assets ka kanina? Paano ko i-distribute ang mga assets na to? Unahin mo yung third persons kasi they have to be protected. Third persons claim. Tabi na, ichapwera na, tapos na eh. O, may iwan ngayon yung mga partners. O, meron ba sa inyo na pinautang yung partnership? O, ikaw, X, o, ikaw muna babayaran. Kasi in the order of priority, ikaw yung sanong. O, bayad na yung utang ng partnership sa'yo, okay, tapos na. O, alis ka na? Hindi pa. Bakit? Partner ako dito eh. Meron pa akong ibang claim sa partnership. Ano yon? Yung capital ko, bayaran nyo sa akin. Okay, so pag meron pang naiwan, after setting yung mga capital nila, yung contributions nila, yung profits will also be distributed to the partners. So yun yung order of priority. Importante yan, no? Importante. The assets shall be applied in the order of their declaration in number 1 of this article to the satisfaction of the liabilities. The partner shall contribute kapag kulang the amount necessary to satisfy the liabilities. An assignee for the benefit of creditors or any person appointed by the court shall have the right to enforce the contribution specified in the preceding number. So magkakaroon daw ng assignee, no, to be appointed by the court. So susundin mo lang yung order of priority dito. Yan. So parang na-reiterate siya dito. Inulit lang naman niya yung nasa portion na ng Article 1839. Ang importante, maalala niyo yung order of priority. Third parties or creditors, outside creditors. Then you have partners in their capacity as creditors, and then partners capital, and then partners profits. Hindi pa pala tapos. Any partner or his legal representative shall have the right to enforce the contribution specified in number 4. So ito number 4. Mag-contribute tayo to satisfy the liabilities. Pwede daw yung i-enforce to the extent of the amount which he has paid in excess of his share of the liability. So dito pala, nangyayari na nakapag-contribute na siya, pero yung contribution niya ay lagpas na sa share niya ng liabilities. So for example, supposedly equal sila. Tiga 100,000 yung contribution. Ang na-contribute niya na 120,000. So ano mangyayari din sa 20,000 and excess yun of his share in the liability? Syempre yung katabi niya na partner, since sumobra na yung bayad mo, kinulangan niya ngayon yung bayad niya. Yung share niya in the partnership liability. Kinulangan niya. Kasi okay lang kulangan na. Sinobrahan mo na yung sa'yo. Eh. Pero sabi mo, lugi naman siya. No, sobrang na nga yung binayad niya. Tapos yung isa kulang. May solution dyan ng Article 1839, number 6. Kapag sobra yung binayad mo, you can have the right to enforce contribution. Mababawi mo rin yan. And then number 7, the individual property of a deceased partner shall be liable for contribution specified in number 4. Ang sabi natin dito, kapag ikaw ay deceased partner, yung mga yung mga utang mo, ibig sabihin yung mga properties rather na may iwan mo will form part of your estate. Now, ang tanong ngayon, can they run after the estate? Ang sabi dito, yes, if they pertain to item number 4. Item number 4 lang. No? Kasi ang sagot natin dyan originally ay hindi. Pero item number 4 provides for that. Ibig sabihin, nag-contribute ng mas malaki yung isa, yung estate yung nagkulang. So ang sasabihin nung partner na nag-contribute ng sobra doon sa kanyang liability, hihingin ko doon sa estate nung namatay na partner. Number 8, when partnership property and the individual properties of the partners are in possession of a court for distribution, partnership creditors shall have priority on partnership property and separate creditors on individual property, seeing the rise of lien or secured creditors. So for number 8, this is just a repetition of all the lessons that we have learned before. Partnership creditors shall have priority on partnership property, separate creditors, individual property. Siyempre, except kung meron silang right of lien as we have discussed earlier, na nauuna sila. When a partner has become insolvent or his estate is insolvent, the claims against his separate property shall rank in the following order. So, ba't may mga A, B, 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 C, C dito? Umuulit siya. Okay? Nangyayari. Anyway, ulit. So, kapag insolvent ang isang partner or yung estate niya, yung insolvent, in case na namatay na siya. So, may dalawang situation na kinocontemplate dito, yung buhay na partner na insolvent at yung patay na partner ay insolvent. So meron siyang claims against at merong claims against his separate property. Naghahabol doon sa insolvent na partner. Insolvent na nga ako. May mga naghahabol sa akin. May mga partners na naghahabol, may mga creditors na naghahabol. May mga creditors ng partnership na naghahabol sa akin. Anong gagawin natin? Uunahin mong bayaran yung separate creditors. Siyempre, diba? Parallel ito. Dahil ang pinag-uusapan ay personal obligations ng isang partner na naging insolvent, then uunahin gamitin yung kanyang property na insolvent na nga siya, pambayad yun sa sarili niyang utang. Okay. Sunod, yung partnership creditors. Yung mga may mga pagkakautang naman doon sa partnership. So, pwede sila maghabol doon sa insolvent na partner kung habulin nila yung separate properties ng insolvent na partners kung nabayaran na nung itong insolvent partner yung mga sarili niyang creditor. And then pangatlo, partners by way of contribution. Si ibang partners, gusto nilang mabawi yung contribution nila pero kulang na nga lang, pwede sila maghabol doon sa separate property ng isang insolvent na partner, pero third sila in the order of priority. Uunahin muna yung sariling creditor ng insolvent partner, yung partnership, yung creditors ng partnership, at yung panghuli na, dulo na, yung contribution ng mga partners. Okay? So, we'll stop muna. We will continue. Akala ko matatapos ko na siya. We will continue with Article 1840 on the next lecture video. Again, I'm just managing yung length ng mga lecture videos natin para hindi naman ako nahihirapang mag-upload sa YouTube. Okay? Thank you very much and see you on the next lecture video starting with Article 1840. Thank you and goodbye.